Hello students, welcome to Analog IAS Academy. Myself Prudhvidhar Reddy. I teach Polity, Governance and Public Administration. If you try to look at the 2024 preliminary examination, 22 questions came up from Polity and Governance portion, out of which 18 questions are for Polity. If you try to look at the quality of questions or composition, most of the questions are conceptual and few are very much factual. The examiner tried to give both the conceptual areas as well as factual areas. But the very happy thing is that whatever we covered in the classroom as a part of Polity portion, most of the questions directly came from the classroom notes only. And in this particular video, we are not just indulging in the identification of right answer, but we will be discussing about some background concepts also. Okay, try to listen the entire video. Coming to the first question, with reference to the speaker of the Lok Sabha, consider the following statements. Okay, so this question is pertaining to the speaker's office. While any resolution for the removal of the speaker of the Lok Sabha is under the consideration, what will be the consequences? That particular aspect is asked here. Okay, so basically Article 96 of the Constitution talks about the removal resolution and the procedure involved here. So actually Article 100 of the Constitution talks about the voting procedure in the Lok Sabha and Rajya Sabha, how the voting takes place. Usually according to Article 100 of the Constitution, the speaker will be exercising casting vote. Okay, so casting vote means what? Whenever there is a tie of votes, when there is an equality of votes, speaker would be exercising the deciding vote. That is what called as casting vote. But Article 96 says the speaker, while the removal resolution against him is under the consideration of the Lok Sabha, in that particular situation, he will be having the right to vote in the first instance itself. Okay, so that is directly asked here. See here, he shall not be entitled to vote on the resolution in the first instance. Naturally, this is what the wrong statement. Okay, and next important two statements, if you try to look at, this is everything is regulated under Article 96 of the Constitution. One, it says he shall not preside, he shall not have the right to speak. See, you understand, you don't require to memorize all these things as we discussed in the classroom. Basically, any law or any constitution that will be governed through principles of natural justice. Okay, so what is that? Principles of natural justice. We discussed what are the principles of natural justice. If you remember these, most of the questions can be answered in the examination. Okay, this is related to due process of law. This is related to presidential removal. This is related to the removal of the judges of Supreme Court and High Court, and also removal of the speaker. Okay, so fundamentally, what are the principles of natural justice? Principles of natural justice means these are the principles which are right according to the moral framework of the people. When something is acceptable according to the moral framework of the people, okay, when something is appearing right according to the perspective of the people, that is called as principles of natural justice. Okay, these include, for example, no man is the judge of his own case. Similarly, no man shall be condemned unheard. Third one, absence of bias. Okay, as well as justice not only be done, it must also appear to be done. This is how we have various principles. You just apply these principles here. What is that? He shall not preside. He shall not preside means no man is the judge of his own case. So naturally, this is the right statement. And coming to the second one, he shall not have the right to speak. Okay, he shall not have the right to speak. This is also wrong according to the principles of the natural justice. Basically, if any person is to be condemned, he must be heard before the punishment is imposed. Okay, you just apply those principles here. You can easily identify the answer. Okay, so what is the right answer? First statement only the right answer. This is how you need to write. You need to pick the right answer. Okay, And coming to the next question, with reference to the Indian Parliament, consider the following statements. So this is about the effect of the dissolution of Lok Sabha over the validity of the bills or existence of the bill or survival of the bills. Okay, basically Lok Sabha is the people's house. When it is a people's house, definitely it has a very highest level of legitimacy over the proceedings of the legislature. So that's why whenever the people's house is in existence, certain bills must be in the existence. When the people's house is not in the existence, certain bills must not be in the existence. This is what the overall logic, okay, right? This logic does not apply only in 3 instances, I will be telling you, okay. First important thing is, if you try to look at these statements here, a bill pending in the Lok Sabha lapses on its dissolution. Yes, of course, just now I told you, whenever a bill is bill is pending in Lok Sabha, that will definitely lapse on the dissolution of Lok Sabha. Basically, this is an important matter we can easily identify. So first statement is correct. Number 2 is, a bill passed by the Lok Sabha and pending in Rajya Sabha lapses on the dissolution of Lok Sabha. So bill is transmitted from Lok Sabha to Rajya Sabha. Okay, whenever the Lok Sabha ceases to exist, definitely the bill has to be considered by new Lok Sabha if it is not passed by the Rajya Sabha. So second statement is also correct. A bill in regard to which President of India notified his or her intention to summon the House to joint sitting lapses on the dissolution of Lok Sabha. Actually, you just understand there are 3 instances, okay, where a bill will not be, what is that, lapsed. Okay, one is if a bill is passed by Lok Sabha and Rajya Sabha, and if it reaches to the president returns the bill for the reconsideration, and meanwhile Lok Sabha is dissolved, so then the bill will not be lapsed. Similarly, if the bill is passed by the Lok Sabha and Rajya Sabha does not pass, okay, Rajya Sabha rejects the bill, or Rajya Sabha approves the bill with certain amendments which are not acceptable to the Lok Sabha, or Rajya Sabha does not pass the bill for 6 months, okay, these instances can be considered to be deadlock, okay, under Article 108 of the Constitution, and the President may be summoning for joint sitting. Okay, in such instance also, even after the Lok Sabha is dissolved, the bill will not be lapsed. And third instance is, the bill is in pending with Rajya Sabha, and Rajya Sabha did not refer the bill to the Lok Sabha. In this instance also, the bill will not be lapsed. Okay, so these are the 3 instances. Hence, what is the right answer here? The right answer is B is the right answer. First and second statements are correct. The third statement is incorrect. Okay, right. Coming to the next important question, with reference to the Parliament of India, consider the following statements. See, I told you many times, okay, the parliamentary form of democracy, if you know the fundamentals of the parliamentary form of democracy, you will be able to answer this question. There is no such difficulty or technicality here, okay. First of all, I told you, in most of the instances, India follows the parliamentary form of democracy where President is the nominal executive and Prime Minister and Council of Ministers are the real executives. Point number 1. Point number 2, in Shamsher Singh versus State of Punjab and Ram Javai versus State of Punjab, in these instances, Supreme Court held that in the Indian democracy, President does not have the discretionary power. This is to be exercised according to the advice given by the Prime Minister and Council of Ministers. Number 2. Number 3 is Article 74 itself. Article 74 itself. Actually, after the 42nd Constitutional Amendment Act as well as 44th Constitutional Amendment Act, we can see a clear point here. What is that? The advice of the Prime Minister and Council of Ministers is binding on the President. 42nd Amendment Act has made binding, but 44th Amendment Act has facilitated the President to return the decision back to the Prime Minister and Council of Ministers for the sake of reconsideration. These are the fundamentals we have discussed in the classroom, okay? Right. On the basis of these fundamentals, let us also understand another important point. See, even the Constitution of India has given, what is that? Situational discretionary power to the President. Situational discretionary power, okay? So you understand why we have given this situational discretionary power to the President. The reason is, there is a synthesis of institutions between the American democracy, that is presidential form of democracy and parliamentary form of democracy in the Indian context. Because in UK there is monarch or crown who is purely nominal authority. Purely nominal authority. In the case of USA, president is the real authority. We synthesized both of these offices and made our president also nominal authority, but we made him powerful in certain situations, not in all the situations. So that's why we can say it is a situational discretionary power of the president. For example, situational discretionary power of the president is exercised in the case of Article 1111 of the Constitution, where the president can send the bill for the reconsideration. That is what situational discretion. Similarly, appointment of the Prime Minister and Council of Ministers. Appointment of the Prime Minister and Council of Ministers according to Article 75 of the Constitution whenever there is a hung legislature. Okay, in that instance also president can exercise a situational discretionary power. Similarly, Article 78 of the Constitution, the president may seek the information from the Prime Minister. Okay, that is how also he can exercise. Similarly, suppose Article 85 of the Constitution, which says there must be session of the parliament without exceeding 6 months between two sessions, without exceeding 6 months duration between two sessions. Okay, in that occasion also the president may ask the prime minister to summon the parliamentary sessions. Okay, or in that manner the president can exercise the situational discretionary power. So except these situations, usually what we must expect, the president must be acting according to the advice of Prime Minister and Council of Ministers. You just keep this in the mind. Okay, right. In this context, you just look at these statements. Okay, right. So first statement is prorogation of the House by the President of India does not require the advice of Council of Ministers. Simply you understand. Prorogation means termination of the sessions of the Parliament. So according to the logic we have discussed just now, definitely see whether this statement is correct or incorrect. Incorrect. Okay, this is how we need to identify the right answers. Okay, right. So next, prorogation of House is generally done after the House is adjourned sine die, but there is no bar to the President of India proroguing the House which is in the session. See, you look at this point very closely. See, in the parliamentary form of democracy, especially in the Indian context, according to Article 85 of the Constitution, the Prime Minister and Council of Ministers, the executive has been given flexibility regarding the number of sessions of the Parliament. But what Article 85 is talking about is there must be minimum sessions of 2. Okay, so more than 2, there can be any number of sessions, number 1. Number 2, why flexibility has been given to the executive? Because executive may be dealing with any matter of public importance or emergency. So in order to deal with the emergency, executive must be having the flexibility to terminate the sessions even when the speaker did not go with the adjournment sine die. So adjournment sine die usually indicates the formal completion of the sessions, but still the sessions, the business is yet to be completed. Still the executive has the power to prorogue the House, prematurely. So that is why this is the second statement which is also correct. Coming to the third statement, dissolution of Lok Sabha is done by the President of India who, save in exceptional circumstances, does so on the advice of the Council of Ministers. Yes, of course, this is also situational discretionary power, where if the President deems that the Prime Minister and Council of Ministers do not have the majority in the Lok Sabha, they may ask the Prime Minister and Council of Ministers to prove their majority, or the President may not be dissolving the Lok Sabha without exploring the possibility of the alternative government, okay, according to his discretionary power, in case the Prime Minister and Council of Ministers do not have the full confidence of the Lok Sabha. Okay, so this is how, what are the right statements. So statement number 2 and 3 are correct, hence answer is C. Okay, right. So then coming to the next question, with reference to Digital India Land Records Modernization Program, consider the following statements. Okay, actually the National E-Governance Project, NEGP, okay, which was launched by UPA government. Okay, this particular program actually envisaged the digitization of land records. Okay, National Land Records Modernization Program was launched in the year 2008. Okay, After Narendra Modi government has launched Digital India program, later in 2016, this National Land Record Modernization Program has been renamed as Digital India Land Records Modernization. And previously it was centrally sponsored scheme, but later it has become central scheme. Central scheme means entire funding is borne out by the central government itself. Okay, so that's why the first statement is correct. And second statement is, under the scheme cadastral maps are digitized. Basically, see, whenever the student comes across this cadastral map, he will get a doubt, what is this map actually about? So according to my view, the schemes are asked in the examination in such a way that to test the objective knowledge of the student. Basically, every scheme will be having certain basic purposes. Okay, there are certain core purposes concerning every scheme. Any question that is asked in this examination, those are pertaining to only the clear objectives only. They did not get into the details of the any particular scheme. So I really appreciate the wisdom of the examiner here. Okay, so it means it is a clear guideline to the student that he must be focusing upon the core concepts of the every scheme. But I would also suggest one more important thing. Please don't get with, don't try to read the second-hand material that is published in the website or some coaching websites. Rather, you just go to the source itself. That will be helping you a lot. Okay, right. So here, cadastral maps means these are the comprehensive maps, which actually talk about the land parcels within the designated area. Okay, land parcels within a designated area. Generally, in the villages, you may come across a Bhu Naksha, so details of very fine details of the land parcels. According to this particular program, even these fine land parcels will be identified. They will be designated with a particular number. So that's why it is also called as Bhu Aadhar. What is that? Bhu Aadhar. So this will be helping in the better ownership establishment, land financing, and even the policy development, as well as land readjustment. These are all possible because of this particular land parcel identification program. Okay, so that's why this particular statement is also correct. And next one is, an initiative has been undertaken to transliterate the records of rights from local language. See, in order to have a better business environment in the country, land is a very, very important issue. The title of the land, okay, and the parcel identification, litigation-free land transactions. Okay, these are all very important. So the basic barrier for all these things is language. Okay, in order to address this problem, so this particular record of rights are being transliterated into the local languages. Okay, by the government of India with the help of CDAC of Pune. CDAC means Center for Development of Advanced Computing. Okay, this is helping in the transliteration. So hence, what is the right answer? The right answer is D. So hence, all the three statements are correct. Okay, right. Coming to the next question, with reference to Pradhana Mantri Surakshit Matritva Abhiyan, consider the following statements. See, this is very, very interesting question as far as my knowledge is concerned. Why? Because examiner has thrown a trap onto the students because of by using this particular question. See, look at this trap, where the trap is. Basically, Pradhana Mantri Surakshit Matritva Abhiyan, this is a scheme to prevent maternal mortality rate. Okay, to reduce the maternal mortality rate. And under this particular scheme, there must be a regular or a particular pattern of hospital visitations by a pregnant women, so that the risk factor for the pregnancy can be tested, identified, and the women records will be labeled either with red color or green color. If red color label is ticked, what does it mean? High risk pregnancy. If green color label is ticked, that is what? Low risk pregnancy. That is how they identified the high risk pregnancies and prevent the maternal mortality. Okay, this is what the objective here. And what this question is about is, this scheme guarantees minimum package of antenatal care. Antenatal care means before pregnancy, to the women, their second and third trimesters of pregnancy and 6 months post delivery care service in any government health facility. So all the portion of the statement is correct except this point. What is that? In any government health facility. Actually not any government health care facility, rather only designated health care facility. This is very, very important. So this actually makes the first statement incorrect. Okay. So hence coming to the next important thing is which of the statements given above are correct. Okay. So of course the second statement is, under this scheme, private sector healthcare providers of certain specialities can volunteer to provide services at nearby government health facilities. This is right. Actually, if you try to look at even National Health Policy of 2017, this policy identifies the participation of the private sector in the public healthcare services. It means the public sector hospitals can strategically purchase the healthcare services from the private sector or get the assistance of the private sector. Okay. So if you keep this point in the mind, you can actually pick the right answer here. So what is the right answer? Second statement is only correct statement, hence answer is B. Okay. Right. Next one, if you try to look at, with reference to Pradhana Mantri Shram Yogi Man Dhan Yojana, consider the following statements. Okay. Actually this particular scheme is applicable to, what is it? Unorganized workers. Unorganized workers means those workers who are not protected with any existing labor legislations. Okay. So those are called as unorganized workers. They don't have the security of social security. Those do not have the social security. Such people are called unorganized workers. So basically in India, 80 to 90% of the workers are belonging to this unorganized workers category. So to get the better benefits to these workers, to get better social safety, this particular scheme has been launched by the Ministry of Labour. So if you try to look at the scheme, this scheme actually applicable to the workers who are belonging to the age group, that is entry group of 18 to 40 years. But what is the statement here? The entry group of enrollment in scheme is 21 to 40 years. Hence, absolutely it is wrong statement. Okay. Number 2, age specific contribution shall be made by the each beneficiary. Of course, age specific means, so there will be contribution different for 18 years age and 40 years age. For example, for 18 years age worker, monthly contribution will be around 50 rupees around. Okay. For 40 years age person, the monthly contribution would be 200 rupees. It means whenever your age increases, your contribution requirement will be changing, okay, on monthly basis. Okay. Hence, this is the first right statement. Each subscriber under this scheme shall receive a minimum pension of 3000 rupees per month after attaining the age of 60 years. This is also right statement. Family pension is applicable to the spouse and unmarried daughters. See, generally students who did not read this point properly, they have the chances to mark this particular statement wrong or right. Okay. For example, look at this point. Actually, this scheme is intended only to the spouse in the case of the death of the actual pensioner. The unmarried daughters do not have any right here. Okay. So hence the right answer for this particular statement is, what is that? 2 and 3, that is B only the right answer. Okay. Right. Next, consider the following statements regarding Nari Shakti Vandan Abhiyan. Okay. So what is this Nari Shakti Vandan Abhiyan? As you know very well, this is 106th Constitution Amendment Act. This 106th Constitution Amendment Act provides a 1/3 reservation for women in the Lok Sabha, state legislative assemblies, and also the UTs of the UT state legislative assemblies. And next important thing is, this particular Amendment Act amended Article 330, Article 332, Article 239 AA. So it is about the legislative assemblies of UTs. Okay. And one more important thing is, this particular reservation has been given within the quota. So quota within quota, we can say. It means for the SC, for example, SC reservation seats are there. Okay. Within the SC reservation, 1/3 seats will be reserved for the women. For the ST reserved category, 1/3 seats will be reserved for the women of STs. Similarly, in the general category also, 1/3 seats will be given for the women belonging to any community. Okay. This is how the reservation is given. Okay. So this is what the basic information regarding this act. One more important thing, this act did not mention about the date of its enforcement. From which date onwards this act is going to be enforced, that details are not given in this act. Why? Because this act has a problem of counting the population, that is census, and also delimitation. Without delimitation means what? Changing the boundaries of the constituencies and also revising the constituencies number in the Lok Sabha and state legislative assemblies according to the proportion of the population. Okay, so that's why there is some legal complexity here. That's why they did not explicitly mention from when onwards this particular reservation policy would be implemented. Okay, so that's why the first statement is absolutely wrong. And moreover, if you try to look at the first statement, the present Lok Sabha itself is 18th Lok Sabha. Okay, if you know this particular point, definitely you would mark this as a wrong answer, because women reservation has not been implemented in these elections. Okay, right. This will be in enforcement for 15 years. Yes, this is a static information, factual information. Yes, it will be implemented or enforced for 15 years. Okay, and there are provisions for reservations of seats for the scheduled caste women within the quota reserved for the SCs. We have discussed this point. So what is the right answer? The right answer would be 2 and 3, hence the answer is C is the right answer. Okay, so this is how we need to mark the right answer. Next, a writ of prohibition is an order issued by the Supreme Court or High Court. Okay, 2. Basically, you know, the fundamental rights are very, very important under the scheme of the constitution because they are justiciable in nature. Justiciability means when your rights are infringed, you will get the relief or remedy from the Supreme Court or High Court. Especially under Article 32, you can approach the Supreme Court. Under Article 226, you can approach the High Courts. Okay, so these articles indicate the Supreme Court and High Court generally issue the writs. Writs means what? Writs means these are nothing but judicial orders to enforce your fundamental rights. Okay, in the nature of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Okay, so these are the 5 writs. In the nature of these writs will be enforced by the Supreme Court and High Courts. And if you try to look at these statements, okay, these statements are related to what is the nature of writ. Okay, basically what is the question about? Prohibition and certiorari. Prohibition and certiorari, both are related to the same thing. Same thing means what? These are the writs which are issued generally against judicial and quasi-judicial authorities. Okay, if you know this fact, you can easily mark the right answer. Okay, right. So where you can find the judicial and quasi-judicial authorities? See here, this is what the third statement, the lower court prohibiting continuation of proceedings in a case. Simply you can easily identify the answer. Okay, so it is a basic question, everybody is expected to answer. Okay, right. Next, coming to the same question, for example, prohibition generally when it is actually issued, what is the difference between prohibition and certiorari? Generally prohibition is in preventive in nature, certiorari is nothing but curative in nature. Both are issued whenever the lower court is exceeding its jurisdiction, whenever it is abusing its powers, whenever it is causing the miscarriage of justice. In such cases, this particular prohibition or certiorari generally issued whenever such proceedings are in the violation of the fundamental rights. Okay, right. Coming to the next question, consider the following statements. It is regarding the governor, okay, governor's power, okay, as well as who would recognize the scheduled tribe category, okay, who would designate a community whether it belongs to scheduled tribe category or not. Actually, you must remember always a basic article under the scheme of constitution, that is article 342 of the constitution. 342 of the constitution. According to article 342, the president recognizes or identifies or designates a community as a scheduled tribe category. Okay, but such designation depends upon the consultation with the governor of a particular state. Okay, so it means governor has been given a role, but only a kind of a consultative role, but not the final role. The final role is given to the President of India itself. The President himself does this, right? So hence absolutely you can say first statement is completely incorrect. And coming to the next important statement here, a community declared as ST in a state need not be so in the other state. That's true. If you try to look at the Lambadas in Telangana, they are not necessarily STs in the Rajasthan. Okay, so that is how you can understand here. So hence second statement is correct statement. The answer is B. Okay, the answer is B. Right. Next, coming to the next question, who was the provisional president of the Constituent Assembly before Dr. Rajendra Prasad took over? This is also a fundamental question, completely factual question. Okay, basically if you try to look at provisional president, the concept of provisional president, still we are following this in the form of pro tem speaker. Pro tem speaker. Okay, this is what called as convention. This is what called as convention, parliamentary convention. Okay, actually this convention was used even with respect to Constituent Assembly, where the senior most member of the Constituent Assembly, who was Dr. Sachidananda Sinha, was made to act as a temporary president till the election of the president of the Constituent Assembly, that is Dr. Rajendra Prasad. Essentially this tradition is a French tradition, a French convention we have employed in the context of the Constituent Assembly, and we are also following the same in the even with respect to the Parliament, that is Lok Sabha. So answer is D is the answer. Next, with reference to Government of India Act of 1935, consider the following statements. Actually, if you try to remember certain facts about the 1935 Government of India Act, a very important fact that flashes in your mind is this act has introduced what? A full-fledged federalism in the country. What is that? A full-fledged federalism in the country. Actually, the federal features of the constitution have been introduced by Government of India Act of 1919 itself, where for the first time it has created bicameral legislature, number one. Number two, it has separated the union legislature, that is federal legislature, central legislature from the state legislature, even separated the budget, okay, of the central government and state government. Certain things have been done, but full-fledged federation, that is even the inclusion of the princely states into the federal polity, has been done by the 1935 Government of India Act. However, of course, this has not been implemented. It has been never implemented before the independence. Okay, so hence first statement is the right statement. Okay, and coming to the second statement, defense and foreign affairs were kept under the control of the federal legislature. See, you just imagine if defense and foreign affairs were given to the federal legislature, simply what does it mean, you know? Simply India got independence. Okay, so hence this second statement is incorrect, where this power has been given to the Governor General himself. So hence what is the right answer? A is the right answer. Okay, next, coming to the next statement, which of the following statements are correct with respect to money bill of the Parliament? Okay, right. So in order to understand the money bill, there are articles, Article 109, Article 110 of the Constitution. These two provisions deal with the money bill. Okay, of course it is elsewhere mentioned, but originally these are the two provisions clearly give about the details of the money bills. Okay, right. So Article 109 mentions about the special provisions or procedure regarding the money bills. Yes, that's true, because Article 109 says the money bill shall not be introduced in Rajya Sabha, and it also mentions about the limited powers of the Rajya Sabha, where when the bill is transferred to Rajya Sabha has to return the bill to the Lok Sabha within 14 days, and Rajya Sabha cannot reject the bill, but of course it can suggest the recommendations, and eventually these recommendations are up to the Lok Sabha whether to accept them or not. So hence in the matters of money bill, Rajya Sabha has been given limited powers. If you try to recollect or recall whatever the concepts I discussed in the classroom, I clearly discussed why Rajya Sabha has been given inferior role in the case of money bill, why Lok Sabha has been given superior role in the case of money bill. Okay, you just recollect. Okay, right. Next, money bill shall not be introduced in Council of States. Of course, that is true according to Article 109 of the Constitution. Rajya Sabha can either approve the bill or suggest the changes but cannot reject it. This is also right statement. And coming to the next statement, the amendments to the money bill suggested by the Rajya Sabha have to be accepted by Lok Sabha. This is not mentioned in the article 109 of the constitution, where it is up to the Lok Sabha whether to accept it or not. Hence, what is the right answer? Okay. Okay. The right answer is C. Okay. 1, 2 and 3 are correct. Fourth statement is incorrect. Okay. Next. Okay. Next one. The Northeastern Council was established by Northeastern Councils Act of 1971 subsequent to the amendment of NEC Act in 2002. The council comprises which of the following members? This is very important question. Basically, if you try to look at first of all the background, zonal councils have been created by State Reorganization Act of 1956. Why these have been created? Basically, these zonal councils are created on the geographical basis. Basically, after the State Reorganization Act of 1956, there was a massive and sweeping changes in the political organization of the country. Okay, and this created a kind of a potential area for the conflict between two neighboring states, okay, which are having the common interest. For example, the southern states of the country, if you try to look at, these are all organized under the Southern Zonal Council. Basically, all these southern states are having common river system, common communication system, common boundaries. Okay, so definitely there is a potential conflict after creation of the new states in the country. That's why the zonal councils have been created, so that the regional matters which are having the differences, okay, between the states can be amicably discussed. Okay, so this can prevent the conflicts between the states and also can provide the coordination between the states, among the states. So these are actually chaired by the Home Minister, and the Chief Ministers will be chairing these zonal councils on rotational basis. Such kind of similar arrangement has been made for the northeastern states in the form of Northeastern Council by means of the Northeastern Councils Act of 1971. Initially, it was having only 7 states. The 8th state, the Sikkim, was added to this Northeastern Councils by means of the amendment took place in the year 2002. Okay, till that point of time, it was part and parcel of the Eastern Zonal Council. Okay, keep this in mind. So, who will be there in this particular council? Okay, governor of the constituent states. Okay, yes, of course, because in the act it is clearly mentioned, governor of the concerned state can be the member. But regarding the zonal councils, governor will not be representing the state in the zonal council. That's why they have purposefully asked this particular statement. And chief minister of the constituent state, that's true. 3 members to be nominated by the President of India. This is clearly mentioned in the act itself. And Home Minister of the India. Basically, Home Minister is the in charge for the states in the country, the internal security, and the Home Ministry will be having the states division. It is a parent ministry regarding any kind of geographical reorganization of any states in the country. Okay, so hence Home Minister is the chairperson. So the right statement is, all these 4 statements are correct, hence the right answer is D. Coming to the next question, how many delimitation commissions have been constituted by the Government of India till 2023, till December 2023? Actually, delimitation means it is a revision of seats in the Lok Sabha and state legislative assemblies after every census. Okay, after every census. And this also includes reorganization of the boundaries. So delimitation includes 2 things. One is revision of seats in proportion with the population changes or demographic changes, number 1. Number 2, reorganization of the boundaries of the various constituencies. These 2 things must be happening. But by 42nd Constitution Amendment Act of 1976, what was done, you know, the freeze on the revision of seats according to the population has been frozen according to 1971 census. Okay, for how many years? 25 years, till the year 2000. Okay, so till the year 2000 there shall not be any revision in the number of seats in the Lok Sabha and state legislative assemblies. Okay, and this freeze has been extended till the year 2026 by 84th Constitution Amendment Act of 2001. So it means only after 2026, according to the fresh census, the delimitation must be done. Okay, but however, 4 delimitation commissions have been appointed. Okay, so these include in the 1953 it was actually constituted, and 1962, 1972 and 2002. These are the 4 delimitation commissions. Actually in 1952 first Delimitation Commission Act was enacted. Delimitation Act would be creating a delimitation commission which will be having the former Supreme Court judge as a chairperson, Chief Election Commissioner as a ex officio secretary, okay, and member, and the State Election Commission is also member in a concerned state, and there will also be associate members from the State Legislative Assembly and Lok Sabha of that particular state. These are actually designated or appointed by the Speaker of Lok Sabha and Speaker of the State Legislative Assemblies. Till now there are 4 delimitation commissions have been appointed, and these 2 delimitation commissions purpose is to just reorganization of the boundaries of the states. Of course, especially the 4th delimitation commission did not have any work to revision of the seats in the Lok Sabha or State Legislative Assembly. Its only purpose is to reorganizing the boundaries of the various constituencies according to the change in the population patterns, that is migration patterns, or you can say to fix the proper composition of the constituencies. This particular delimitation of the constituencies has been conducted. That is only pertaining to the reorganization of the boundaries itself, okay, not regarding the revision of the seats. Okay, remaining 3 delimitation commissions have been indulged in the revision of the seats as well as readjusting the boundaries of the constituencies. So hence the answer is D is the right answer. Okay, next delimitation commission is going to be appointed after 2026 according to the fresh census. Next one, the Constitution 71st Amendment Act of 1992 amends the 8th schedule to the Constitution to include which of the following languages. Actually this is also purely a factual question. So if you remember the recent Amendment Act, okay, you can easily eliminate the wrong option here. Basically by 92nd Constitution Amendment Act of 2003, okay, 4 new languages have been added to 8th schedule. These include Bodo, Dogri, Maithili and Santhali. If you know this particular fact, okay, you can easily eliminate what is that? Maithili. Okay, right. And so what is the right answer here? Konkani, Manipuri and Nepali. The answer is A is the answer. Okay, it is purely factual question. You need to remember certain things mandatorily, because in frequently I told you in the class also, please make the parts of the Constitution schedules, okay, in your notes, okay, so that you can easily get the factual information here. And next important question is, this is about post-independent consolidation. Consider the following pairs: Bharatiya Janasangh, Socialist Party, Congress for Democracy, Swatantra Party. 4 political parties have been given, and he is asking what is the right pair here. Okay, how many pairs are correct? Okay, right. Bharatiya Janasangh, it has been established by Shyam Prasad Mukherjee. Even today also he is the ideologue for BJP. And Socialist Party, it was actually founded by Acharya Narendra Dev. Okay, his name must be given here. So hence this is the wrong match. And Rajagopalachari has established a Swatantra Party. So this is the right match actually, but it has been given wrongly. Hence the 4th statement, 4th pair is also incorrect. Congress for Democracy was established by Jagjeevan Rao. So hence both pairs are correct. So the right answer is only 2. Okay, right. Next, coming to the next one, which of the following statements are correct about the Constitution of India? This is purely factual question. If you know the parts of the Constitution in a chronological order, you can easily identify the right answer. Okay, so Part 9A, Panchayat Raj municipal bodies. Part 9 is about Panchayat Raj institutions. Part 18 is about emergency provisions. Part 20 is about amendment of the Constitution. Okay, so hence the right answer is D. Next, which of the following statements is correct as per the Constitution of India? See, answering this question is very easy. You don't require to struggle for this answer anymore. Why? Because any interstate matter that is there in the country, that must be belonging to the union list only. This is for sure. Okay, any interstate matter which is there in the Constitution must be belonging to union only. So taking that particular logic into consideration, first statement is incorrect. Basically, interstate commerce trade, definitely it will be found in the union list. So this is found under the union list under the entry called entry number 42. Okay, coming to the next one, interstate migration and interstate quarantine, both are mentioned under entry number 81 of the union list. Okay, so hence second statement is incorrect, it is not in the state list. If you try to look at the fourth statement, corporation tax is the state subject under state list. See, corporation tax is one of the high yielding taxes for the central government along with the income tax and other taxes. So by default you will come across this term in the economy also. So hence the fourth statement is also incorrect. Basically it is mentioned under entry number 85 under the union list. Okay, what is the right answer here? C is the right answer. Got my point? So this is how you need to choose the right answer. So logic is simple, interstate matters must be definitely found in the union list only. Next, under the following articles of the Constitution of India has the Supreme Court of India placed the right to privacy? See, this is fundamental and basic question, that is nothing but Article 21 of the Constitution. If you are able to recollect the discussion regarding Article 21, some Supreme Court judgments held right to privacy is not fundamental right, like Khadak Singh versus State of Uttar Pradesh. Okay, simply what is that, MP Sharma versus Satish Chandra. Okay, in these cases Supreme Court held that right to privacy is not fundamental right. But Supreme Court in Puttaswamy versus Union of India, okay, in 2017, as well as PUCL versus Union of India, that is popularly called as wire tapping case, phone tapping case. In these cases Supreme Court held that right to privacy is fundamental right. So answer is D. Next, coming to the next question, what are the duties of the Chief of the Defence Staff as the head of the Department of Military Affairs? Actually, this Chief of the Defence Staff for the first time recommended by Kargil War Review Committee. After that, Narendra Modi government, actually Vajpayee government itself contemplated this kind of office, but it was materialized during the Narendra Modi government in 2019. So actually he is a permanent chairperson of Chief of Staffs Committee. Previously there used to be Chief of Staffs Committee, all the three forces will be members of Chief of this particular Staffs Committee, and the tri-forces, Air Force, Navy and the military, those used to be given the chairman position on rotational basis. But after the establishment of CDS, that rotational basis was abolished and CDS has been made as permanent chairperson, who is a 4-starred official, okay, and exercise military command over the 3 service chiefs. Actually this officer has a role of coordination but not any kind of commanding, hence the second statement is incorrect. And principal military advisor to the defense minister on tri-services matters, that's true. So hence the right answer is D. 1 and 3 is the right statements. See, I told you already, questions are very much objective. They are asking only the core of the concepts. If you know the core of the concepts, you can easily identify the right answers. And last and final question, which of the following statements about the ethics committee in the Lok Sabha are correct? Actually, there are three statements given. Why ethics committee question was asked? Basically, TMC MP Moina Mitra has been disqualified or expelled from the house. Okay, in this context, this particular question has been asked. Actually, this ethics committee, if you try to look at in the case of Lok Sabha, for the first time it was established under the leadership, that is a chairmanship, that is speakership of GMC Balayogi, who initially made it as a ad hoc committee in the year 2000. You know, parliamentary committees are those committees which are appointed by the presiding officer of any given house. Secretarial assistance is given by the parliament itself, and the third one is they will be submitting their reports to the presiding officers. If any committee qualifies these statements, that is a parliamentary committee. Next important thing is, in any parliamentary committee, no minister will be member, right, except the consultative committees. And why parliamentary committees have been established? In order to have effective supervision over the government. Basically, the parliament, especially in the Indian democracy, the problem is there are only limited number of parliamentary sessions, and that too on the discretion of the executive. Because of this reason, the effective supervision is lacking over the government. In order to fill this gap, various committees have been constituted, okay, which include standing committees and ad hoc committees. Standing committees are called as permanent committees, ad hoc committees are called as temporary committees. Ad hoc committees are established to solve a particular purpose. Once such purpose is solved, the ad hoc committees will be ceasing to exist. Okay, the very good examples for the ad hoc committees include select committee and as well as joint parliamentary committees. Okay, and standing committees include finance committees and department related standing committees. Like that, there are various committees. Here, this particular ethics committee has been constituted only as ad hoc committee initially in the year 2000. Later in the year 2015, this ethics committee has been made as a standing committee or continuous committee. So hence first statement is correct. Only member of Lok Sabha can make a complaint. Actually, it is not so. Any person can be making the complaint. But of course, there is a difference. If a person makes a complaint, he has to file the affidavit. But if an MP makes a complaint, he does not require to file the affidavit. This is the only difference. Affidavit means undertaking, okay, given by a person that whatever the statements he is giving, those are truthful. So that kind of undertaking must be given. Okay, hence the second statement is incorrect. Coming to the third statement, the committee cannot take up any matter which is in the sub judice. Yes, this is the right statement. Actually, the committee cannot take up two matters. One is the matter which is according to the media reports, number one. Number two, when the matter is under the sub judice, which is under the examination by any given court in the country. So hence, what is the right answer? Okay, C is the right statement. C is the right answer. Okay, which covers both statement number 1 and statement number 3. Okay, statement number 1 and statement number 3. So coming to the next question, question number 65. With reference to union budget, consider the following statements. See, this question tests your knowledge regarding two articles, Article 112 as well as Article 75, Class 3. Okay, basically students will be generally misled that finance minister introduces the budget on behalf of prime minister. Actually, it is not true. Basically, Article 112 says the president shall cause the annual financial statement to be laid down in the Lok Sabha. So that is what is given in under Article 112 of the Constitution. Hence, finance minister lays down the budget on behalf of the president, not on behalf of the prime minister. That is number one. That is according to Article 112. Article 75 Class 3 says there must be a collective responsibility of prime minister and council of ministers to the Lok Sabha. So hence, whatever the act that is done by the finance minister, it is on collective responsibility. Okay, that's why the first statement is incorrect. Coming to the second statement, at union level, no demand for grant can be made except on the recommendation of the President of India. Okay, actually this is true because Article 113 says definitely even on the demand for grant, the presidential prior assent is required. So hence, second statement is correct. So the right answer is B. Next, coming to the next question, question number 76. As per Article 368 of the Constitution, Parliament may amend any provision of the Constitution by the way of. I repeatedly told you people in various classes, Article 368 Class 5, okay, which has been added by 42nd Constitution Amendment Act, okay, which clearly lays down a particular provision that the Constitution is amended by means of addition, variation and repeal. So these three things covered under the concept of amendment of the Constitution. So hence the right answer is D. So 1, 2, 3, all the statements are correct. Okay. So this is what about the preliminary key and explanation. Thank you.